How many times does an attorney have to do something horrible in court in order to be held in contempt by the judge? You want to know the answer? Come join with me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. There is no set definable number of times an attorney has to do something bad or improper in order to be held in contempt by the judge. Now, what does it mean to be held in contempt? Well, here's the process. Let's say an attorney is at trial. Now, it's a medical malpractice trial, for example. And now he says something that is inappropriate. You know, there's a certain level of decorum that goes on in the courtroom. The attorneys are required to be dressed professionally. That's a requirement. If we walk in a t-shirt and shorts, the judge is going to yell at us. Counselor, you're disrespecting me, you're disrespecting the institution, you're disrespecting the court. Go home and get dressed. That's what the judge is going to say. And that's not a good thing to walk into court in a t-shirt and shorts as the attorney. Now, let's say the judge has made a ruling about a piece of evidence that cannot come in. And now the attorney keeps holding up that document that he wants to introduce into evidence that the judge has already ruled cannot come in. Now the defense attorney jumps up and objects. The judge again admonishes the attorney, saying, "Counselor, I told you not to talk about that." And now a few minutes later, the attorney does it again. And again, the same outburst occurs. The same drama occurs. The defense attorney jumps up like a yo-yo out of a seat with a spring in his chair. He screams and yells. The judge again now is getting angrier and angrier at the attorney. And finally, he turns around and says, "Counselor, you do it again, I'm going to hold you in contempt." So what exactly does that mean? It means you are disrespecting the judge. It means you're disrespecting his rulings. And when you do that, now there's a whole host of possibilities that can occur. What the judge is basically saying is, stop it. You're doing something legally improper. You're doing something unethical. And now if you continue to do that, I am going to punish you. That's what it means to be held in contempt. And the judge has many options available to him in order to enforce that punishment. So now you walk into any courtroom in New York, there will always be a court officer in the courtroom. That's the power, that's the enforcement here. The judge also has the ability to dismiss the case. The judge has the ability to fine and sanction the attorney monetary penalties in the sum of thousands and thousands of dollars. He can tell the attorney that he is going to be personally responsible for thousands of dollars in fees and in penalties, all because he has failed to listen to the court. He's failed to listen to the judge's rulings. He's failed to abide by the attorney's professional code of conduct. And all of that can occur. The judge can also refer the attorney to the grievance committee, and now they can go ahead and investigate this attorney's actions during the course of this trial. If this rises to the criminal level, now the judge can turn around and say, "Hey, I'm going to refer you to the district attorney's office," and then the district attorney will go ahead and investigate whether or not his actions rise to the level of criminal conduct. So the judge has many options available to him. But the point was, what does it mean to be held in contempt? It means you've done something wrong. And now, in all these civil trials involving an accident matter, a medical malpractice matter, or even a wrongful death matter that are held in court at trial, these are all jury trials, or at least almost all of them are jury trials. Which means if the attorney is throwing a tantrum, if the attorney continues to disregard what the judge is saying, how do you think the jury sees the attorney? What do you think is going on in their mind when they see an attorney who's so rebellious to the judge's authority? Do you think they're going to favor his side? Do you think they're going to lean in favor of his client's claim? In all likelihood, the answer is no. Why? Because they look to the judge as the authority in the courtroom. And he is the authority in the courtroom. What the judge says goes. How dare the attorney disregard what the judge told them to do? Not just once, not twice, not 3 times, 4, 5, 6 times. The attorney didn't listen. Did he not get it? Did he not process that this was improper? Again, how is the jury going to perceive this attorney's actions? Now, the attorney can always turn around and say the judge was treating him unfairly. Sure, that can always happen. That can happen. And the attorney has to make a record to preserve whatever is occurring in court so that now he may have to appeal that issue later on if he loses the case. But from the standpoint of the trial, how is it going to look if now the judge turns around, starts yelling and screaming at him and says, "You violated my orders, you didn't listen to me, and now you're going to suffer the consequences. I'm going to hold you in contempt"? Is one option that he can be put in jail? Yeah, that's an extreme option. It doesn't really happen in civil cases, and you don't really see that occurring from the medical malpractice or accident or wrongful death trial standpoint. So why do I share this great inside look into how this works? I share it with you to help you understand exactly how this process works and what it means to be held in contempt. You know, I recognize and I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.